Hello everyone, I am Nathan. Welcome to my channel, The Law Guide. So today I'll be discussing the idea of a legal system and its characteristics. It is important to understand some key words in this topic. Number 1, system. System connotes an ordered set of ideas, theories, or principles interacting within a given framework or even a body. Legal. Legal can be defined as anything relating to law. So what is Nigerian legal system? The Nigerian legal system in this sense consists of the totality of laws or legal rules and which are obtained within Nigeria as a sovereign and independent African country. Nigeria, as everyone knows, is a country which got our independence in 1st October 1960. Now, let's look at legal system. Now, for there to be a viable legal system within an area, especially here in Nigeria, there must be in place a certain ultimate principle from which other laws and acts are derived, but which are in themselves self-existent. Now, that foundation for all the rules in a normative system has been variously described as the GRUNDNORM. Now, what is the GRUNDNORM? GRUNDNORM can be defined as the highest norm or the fundamental norm from which other sources derive its power. Now, Nigeria operates the common law, and guess what? Nigeria, under the British colonial rule, derived legal authority from the Queen in Parliament, and that was then prior to independence, which Nigeria got. That was October 1st. But within the attainment of the independence in 1960 and subsequently under the Republican Constitution of 1963, the GRUNDNORM shifted from the Queen in Parliament in Britain to the Constitution. That was the Constitution of the Republican Constitution of 1963, and in fact, Section 1 of that Constitution contained in the declaration that the Constitution will have the force of law throughout Nigeria and subject to the provisions of Section 4 of the Constitution, granting Parliament the power to alter the Constitution if any other law is inconsistent with this Constitution. This Constitution shall prevail, and the other law, to the extent of inconsistency, shall be void. Now, that was the Constitution, the Republican Constitution of 1963 then. But the latest one we have now that is in place and operative is the 1999 Constitution of Nigeria as amended. And so, in order for you to get this, you check this in Section 1, Sub 3 of that Constitution. 99 Constitution, the Nigerian Constitution, 1999 as amended. Also, let's go to the characteristics. The characteristics, number 1 is duality. Now, Nigerian legal system has acquired a dual structure comprising of the customary laws and the English laws. In addition, you can see the Islamic laws, which has a great impact in the northern part of the Federation, and the customary, as we all know, in the southern part of the Federation. Number 2 is volume of external influence. Now, sources has been borrowed from diverse external sources. The laws that apply here in Nigeria has been really borrowed from external sources, such as the Islamic law, which is derived from the 19th century Fulani Jihad. Yes, it was derived. The Islamic law we use right now, if you go deep into it, it was derived from the 19th century Fulani Jihad. The English law still remains the major source of Nigerian law. Yes, nothing can actually change it. That is the GRUNDNORM. Attempts to reshape this, there have been several attempts to reshape this really, but then it ended up that every local statutes, every act and all laws are still to the GRUNDNORM, which is the constitution, and as you can see, still got it from the common law. Number 3, diversity. This characteristic can be easily seen from the different countries' ethnic groups and cultural units. It is believed that this country, Nigeria, have more than 250 ethnic groupings in Nigeria, and each of them having its own peculiar customs and norms, differing in some ways. And you can imagine that simply means that all these cultural groupings will be having their own laws which guide them and which supervises their actions. Number 3 is the system of precedence. Now, Nigeria has imbibed the tradition of the stare decisis, which states that earlier decisions made by a superior court should be binding or be binding authorities in subsequent cases in the lower courts. And when the Supreme Court has decided, has given a decision in a case, the decision becomes a law, and lower courts are to take it into consideration in such similar cases. Yes, this practice certainty and predictability in law, and also minimizes the influence of personal bias against settled principles of law. You can imagine where there had already been a decision made already, and it's been seen as a law, and the lower courts decides to make it to be to please himself or to please itself. That can actually happen because of the system of precedent, the stare decisis. Number 5, we have the order of judicial hierarchy. For precedents to run smoothly, Nigeria has a well-structured hierarchy in its judicial setup. The Supreme Court, being the highest court, occupies the apex. And hearing appeals from the Court of Appeal, there are other superior courts of record below it. We have the federal and state high courts. We have the customary court of appeal, the Sharia court of appeal, and below are the inferior courts, where we have the magistrate courts, we have the area courts, we have the customary courts also. And also we number 6, we have number 7, we have the fusion of legal profession. Legal practitioners in Nigeria are trained as barristers and solicitors within a unified training scheme at the university, and thereafter they go to the law school and they are admitted to the bar as solicitors and advocates of the Supreme Court, combining the duties of both callings and all. Number 8, we have the acquisitorial or adversary system. The Nigeria operates the acquisitorial or adversary system, unlike some foreign jurisdictions that operate the inquisitorial system. In the inquisitorial system, the court is expected to partake directly in the resolution of disputes and prosecution of offenders. But here in Nigeria, the acquisitorial system which we practice, courts are advised not to detach and not to attach themselves to the disputants, and to maintain a neutral stand. In order for the case to run smoothly and not to cause chaos. And lastly is the military influence. Well, the impact of the military in Nigeria's political development in the past has really left an indelible mark. on its legal system. Successive military regimes assumed executive and legislative. The military regime those days, they focus on the executive and the legislative responsibility, and they left out the judicial function. They left it all out. They had no regard for it. They ruled by decrees and edicts, very strict. They were very strict. There was no freedom for the citizens of the country. Then it is a fact that the military regimes in Nigeria have been more active in the areas of law reforms than even the civilian government, except for the breaches of the fundamental rights and abuses of the rule of law.